Hello guys, I'm Mitali Singh and I'm currently interning under LEXIS and Company, and with this video I will be talking about one of the important topics under the Indian Contract Act, which are contract of indemnity and the contract of guarantee. So firstly we will be discussing the basic introduction to the contract of indemnity and contract of guarantee under Indian Contract Act. So, contract of indemnity is a contract by one party to keep the other harmless against loss, but a contract of guarantee, on the other hand, is a contract to answer for the debt, default, or miscarriage of another who is to be primarily liable to the promisee. Contracts of guarantee and contracts of indemnity perform similar commercial functions in providing compensation to the creditor for failure of a third party to perform his obligation. Now I will jump on to the topic contract of indemnity. A contract of indemnity is defined under section 124 of the Indian Contract Act. The contract of indemnity as per section 124 of Indian Contract Act 1872 is defined as a contract by which one party promises to save the other from loss caused to him by conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. The key fundamentals of a contract of indemnity are: it is a promise to compensate for or security against damage or loss or injury. Second, in wider sense, it includes all contracts of insurance guarantee. It is not a collateral but an independent contract. Third, it is a tool for allocating risk contingent liability. And lastly, indemnity clauses, amongst other things, must be clear, specific, where possible stipulate the circumstances under which the indemnity will arise, be considered in light of any exclusion of liability clauses found elsewhere in the agreement, and state that damages will be payable in the event of clause being successfully invoked. Basically, we conclude that contract of indemnity includes two parties, which are indemnifier and indemnity holder. The person who is promising to pay compensation is called indemnifier, and the person whose loss is compensated is called indemnity holder. In contract of indemnity, the promisee in a contract of indemnity, acting within the scope of his authority, is entitled to recover from the promisor all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. Second, all cost which he may be compelled to pay in any suit, if in bringing or defending it he did not contravene the orders of the promiser and acted as it would have been prudent for him to act in absence of any contract of indemnity, or if the promiser authorized him to bring or defend the suit. Now we jump on to our second topic of this video, which is contract of guarantee. So, contract of guarantee is specified under section 126 of Indian Contract Act 1872. A contract of guarantee as per section 126 of Indian Contract Act 1872 is defined as: a contract of guarantee is a contract to perform the promise or discharge the liability of a third party or a third person in case of his default. So, in simple language, it means that if a third party or if a third person fails to perform his duty, then the person who has given the guarantee in respect of the third person will compensate the loss, or the person who has given the guarantee will pay. So the person who has given the guarantee is called the surety. The person in respect of whose default the guarantee is being given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. So we conclude that in contract of guarantee there are three parties. First is the debtor, second is the creditor, and the third is the surety. Under a contract of guarantee, the guarantee can either be in oral or in written form. Now we will be talking about the key fundamentals of a contract of guarantee. So the fundamentals, or we can say that the essentials of a contract of guarantee are: first, a guarantee is a contract to answer for the payment of some debt or the performance of some duty by a third person who is primarily liable for that payment or performance. Second, it is a collateral contract which does not extinguish the original obligation for payment or performance. It is rendered null and void if the original obligation fails. In case of guarantee contract, there will be two types of liabilities, namely primary liability and secondary liability. Primary liability will be with the principal debtor and secondary liability will be with the surety. In contract of guarantee, the liability arises from the very beginning. The surety becomes liable when the principal debtor commits default in meeting the liability. So we are done with the contract of guarantee and the contract of indemnity. So thank you. That's it for this video. I will see you in my next video.